Ready, start. Here the respondent filed the complaint after the grant of divorce. A month later, granted that the same is not expressly prohibited by law, it certainly begs the question as to why, despite having been separated from the appellant for almost 3 years to the date, did the respondent consider filing an application with the police at that relevant time to entertain the possibility that the same is nothing but a counterblast to the fact that the appellant has two orders in his favor, one by the courts in Austria ordering the respondent to bring the child back to Australia, and the other by the courts in Australia accepting the appellant's prayer for grant of divorce, does not appear far-fetched. That apart on our own analysis, we find the conduct of the respondent to be questionable. Despite there being orders of the concerned courts in Austria, the child, as alleged by the appellant, is yet to be returned to Australia either with or without her mother accompanying her. This position of the appellant has not been controverted by the respondent. Further, we find that when service was to be effected for the papers of divorce proceedings initiated by the appellant, the same was made in India. This, to our mind, casts doubt on the genuineness of the respondent for the reason that one of the arguments she made in favor of her position of wanting to keep the child in Austria was that she had been integrated in the society there. Well, if that was the case, the child ought to have been in Austria even today if we keep aside the decree of the courts there, asking the respondent to do quite the opposite. One of the allegations made slash apprehensions listed in her complaint is that there is a possibility that the appellant may abduct her child. Even though in the eventual FIR such allegation does not translate into a charge, the mere presence of the statement makes us believe that a picture far from the truth has tried to be painted. In fact, it was against the respondent that the charge of unilaterally removing her child from the joint custody of both the parents was prayed in the court of law, and she was directed to remedy the situation. We may only wonder how that can be. We may also observe that while it may be true that India is not a signatory to the Hague Convention 1980 and that the criterion may allegedly differ, it does not give us reason to interfere with orders passed by courts of competent jurisdiction in other countries. It cannot be disputed that the courts in Austria had jurisdiction. They decided a dispute as per the applicable law. No occasion whatsoever arises for India to apply its standard. The limited consideration given to the findings of the courts in Austria is that a decree to take child back to Australia had been passed, and as it appears the same has not been followed.